Attorney-General.
Thank you, Madam Speaker. And I rise to support the Fines and Penalties Recovery Amendment Bill cognate introduced by Minister Burgoyne. Madam Speaker, it was just days before the former Labor government entered caretaker mode before the 2024 general election, which we learnt about this decade-long debacle, and it was identified with the recovery of fines such as speeding or parking fines, which had some problems, meaning that whilst those fines were still payable by law, the enforcement of the fines recovery was put on hold while processing issues were resolved. And the CLP government is now fixing these issues with these legislative amendments to address issues relating to the enforcement orders for these unpaid fines and penalties. The Minister for Corporate and Digital Development said, "We are taking decisive action and cleaning up this long-term issue created by administrative oversights that potentially goes back as far as 2002. All fines and penalties are still valid and have always been payable. The amendment relates to enforcement orders and enforcement sanctions implemented when fines and penalties were not paid by the due date. We know that as at the 30th of June 2024, there were 201,541 outstanding fines and infringements worth a total of $119.6 million. Of this, around $102.3 million is money owed to the Territory Government. In the NT, annually, between 50,000 and 60,000 fines and infringements are issued. When the bill is passed, historical enforcement actions will be retrospectively validated. We back the actions of the Fines Recovery Unit, which will continue to operate, and they are strongly supported, Madam Speaker. Recent machinery of government changes saw the Fines and Recovery Unit and the management of the Fines and Penalties Recovery Act 2001 move from the Attorney-General's Department to the Department of Corporate and Digital Development. It's important that a fine system and a fines recovery system is watertight so that those who do the wrong thing know there is a consequence. Equally, that when it comes to enforcing collection of these fines, the process is swift and irrefutable. This legislation ensures the recovery of monies payable to the Territory arising from penalties imposed by infringement notices and fines imposed by the court as a penalty during court proceedings. The infringements or fines are issued by various enforcement agencies, including NT Police for speeding offences and other offences where an infringement may be issued, councils for parking offences and other infringement offences, agencies such as the Department of Health, which may undertake regulatory enforcement actions through the issue of an infringement notice. The Fines Recovery Unit is responsible for making sure that fines and penalties are paid. If someone does not pay a fine from an infringement notice or a court within the set time, that fine becomes a debt owed to the Territory. The Fines Recovery Unit can then take action to collect this debt unless the person has decided to take the matter to court or has requested a rehearing or appeal. To collect unpaid fines, the Fines Recovery Unit can issue enforcement orders. This allows them to take further actions like suspending driver's licences or publicly naming people who have unpaid fines to encourage payment. These measures are commonly used across Australia to ensure fines are paid and to maintain a strong system for dealing with penalties. In June 2024, problems were found with how the Fines Recovery Unit was enforcing these unpaid fines, and as a result, they had temporarily stopped their enforcement actions while working on fixing these issues. And this bill is the first step in helping the Fines Recovery Unit get back to enforcing and collecting unpaid fines. Madam Speaker, fines, infringements and the recovery of such play a crucial role in accountability in the Northern Territory. Fines and infringements can act as a strong deterrent, serving as a warning to individuals that certain behaviours are unacceptable. The potential for fines encourages people to follow laws and regulations which help prevent misconduct. Enforcing infringements ensures that individuals are held responsible for their actions. Personal responsibility is paramount. Many infringements, such as traffic violations, are designed to protect public safety. By enforcing these rules, our police and authorities help reduce accidents and promote safer environments for everyone. The collection of fines can also contribute to additional public funds, which can be used for community services, infrastructure and other essential programs, all very much needed here in the Northern Territory, Madam Speaker. Whilst the hope is that people do the right thing and fines are not issued, sadly people are imperfect. So issuing of a fine not only acts as a deterrent, but knowing they go back into the community means the collections can be put to good use. The enforcement of infringements can encourage individuals to change their behaviour. Knowing there are consequences for certain actions can lead to more responsible choices. And infringements also help establish and uphold community standards and the norms. And by enforcing rules, the Territory can maintain its values and expectations. Overall, the effective utilisation and enforcement of infringements are vital so that we can have a safe, fair and orderly Northern Territory. Madam Speaker, I commend this bill to the House.